सैकड़ों विधि हजारों विधान, जो जोड़कर सबको साथ रखे वो है संविधान. A very warm and hearty good morning to our esteemed dignitaries, faculty, and my dear batchmates. We have all gathered today for the 4th edition of Constitutional Law and Lecture Series hosted by Manipal Law School under the guidance of our esteemed director and honorable professor, Dr. Avinash Thadij. The theme for today is constitutional law and social justice. Our constitution is not merely a document, it is the cornerstone of our nation, embodying the values of equality, justice, and liberty for all. It provides the framework for our laws, guiding us in times of both calm and crisis. Yet, we must remember that a constitution is not static. It evolves with the changing needs of society and the progression of human rights. At the heart of constitutional law lies the principle of social justice. It is the idea that every individual, regardless of race, gender, religion, or socio-economic status, is entitled to fair treatment and equal opportunities. Social justice is not a lofty aspiration, but a fundamental necessity for a truly democratic society. However, we must acknowledge that achieving social justice is an ongoing struggle. Discrimination, inequality, and systemic injustices continue to plague our communities. As guardians of the Constitution, it is our duty to confront these challenges head-on and strive for a just and more equitable society. Manipal Law School aims to recommit each one of us to ideals of constitutional law and social justice. We aim to work tirelessly so as to build a society where justice is not just a privilege, but a right for all. Together, we will create a future where every individual is treated with dignity and respect, regardless of who they are and where they come from. Without any further ado, I request all our esteemed dignitaries to come up on the dais along with our director and faculty members for the lighting of the lamp.
या कुन्तेन्दु तुषारहार धवला या शुभ्रवस्त्रावृता या वीणावरदण्ड मण्डितकरा या श्वेतपद्यासना या ब्रह्माच्युत शङ्कर प्रभृतिभिः देवे सदा वन्दिता सा मा पातु सरस्वती भगवती निशेषजाड्यापहा गुरुर्ब्रह्मा गुरुर्विष्णु गुरुर्देव महेश्वरा गुरुर्साक्षात् परमब्रह्म तस्मै श्री गुरुवे नमः रक्तबीजबधे देवी चण्डमुण्डविनाशिनी रूपं देहिं जयं देहिं यशो देहिं दिशो जहि
Ladies and gentlemen, I request you all to give your complete attention to the panel ahead as we are going to display a presentation which represents the ideologies of MAHE and will help our esteemed dignitaries to understand Manipal Law School in a much better way. I request the audio-visual team to please play the video.
Thereafter, Venkatesh.
Okay, sir. Now, I request the audiovisual team to connect us with Lieutenant General Dr. M.D. Venkatesh, the Vice Chancellor of MAHE, so that he can share his thoughts with us virtually.
Very good morning, everybody. Am I audible, please? Audible? Yeah. Very good morning, everybody, and warm greetings to all of you from Manipal Academy of Higher Education, an institution of eminence deemed to be university. It's a matter of great pride for us at Manipal and at our newest campus at Bengaluru, our newest law school is organizing this wonderful event that the Constitutional Law Lecture Series. And this one is the fourth in the series. The first three have been very well received and has benefited a number of legal professionals and our students who are part of the Manipal Law School. To all the dignitaries on the dais, my pranams, warm regards, and my greetings from Manipal Academy of Higher Education. It's a matter of privilege for us that this fourth in the series of Constitutional Law Series lecture is being organized on the 4th of May with participation from some of the best known names in the legal professional, some sitting judges from Supreme Court, High Court, and legal academicians from across the world. I am given to understand that there is going to be a large participation not only from the students but also from people who are practicing law in various areas within the country and outside. This is an extremely important occasion for us, and on behalf of the university, let me express our sincere gratitude to all the legal luminaries who have made it convenient to be there at Bengaluru and who have consented to address the gathering and the faculty. I'm sure their wisdom and sagacity is going to lend a lot of, will disseminate a lot of new knowledge to all our students and the participating members for this very prestigious conference. And I apologize that I'm not been able to be there in person, but I took time off to be part of you in a virtual mode. And let me compliment Dr. Avinash Sadish and his entire team for conceptualizing and conducting this event in such an exemplary fashion. And I'm sure this lecture series is going to become a permanent feature of the Manipal Law School curriculum, and that learning from the doyens in the field of legal education and legal practice is going to benefit our students and the others who are attending the conference immensely. Once again, congratulate Manipal Law School for organizing this event, and as Manipal Law School, within the establishment of the school within the last 2 years has grown by leaps and bounds and is aspiring to be ranked amongst the best law schools in the country. And once again, I thank all the legal luminaries who have joined here, both online and offline, and I wish this lecture series all the very best. And I think it's a very important topic that is being discussed today, constitutional law and social justice, very relevant to the current times, and I'm sure this will enlighten the people who are attending this conference both offline and online immensely. Thank you once again to everybody who has made it convenient to join this event, and I wish this event all the success. Jai Hind.
Thank you, sir, for giving us this opportunity and embracing us with your presence. Now, I would like to welcome Dr. Rahul Mishra, Associate Professor of Manipal Law School and the head of our Constitutional Law Lecture Series, to give a brief introduction of the program.
Thank you, Vidushi. Vena Rakshita Dharma, Syat Dharmena Vinashyati. When it comes to the essence of this shloka that emphasizes the importance of righteousness or dharma in upholding the order and balance in society, it also does suggest that when people adhere to the principles of righteousness, it not only protects the moral order, but also ensures the well-being of society as a whole. When it comes to the second line of this shloka that highlights that in situations where righteousness is considered the highest virtue, that is truth satyam, and non-violence ahimsa, naturally prevails. Therefore, this shloka does advocate for the prioritization of dharma, truth and non-violence in all aspects of life, as they form the foundation of the just and harmonious society. And the vibrant hues of legal enlightenment, we extend a heartfelt embrace to our esteemed guests whose presence graces are gathering with profound significance in the luminous constellation of legal luminaries. Do allow us to introduce with utmost reverence and admiration my heartfelt pranam to the dignitaries on the dais, Shri Indresh ji, Shri Varale ji, Madam Varale ji, Shri Avinash ji, Shri Thakurji, esteemed gathering in terms of audience who have gathered here. Once again, my heartfelt salutation to you all. When it comes to the conception of this idea was born in Manipal Law School 2 years back, with just only one goal in mind, that let us try to illuminate the minds around as far as the nuances pertaining to the Indian Constitution are concerned. And I will express my thankfulness to our Honorable Director, Professor Avinash Dadiji, who accepted this idea and who gave us all that strength. And I am also thankful to the MAHE administration for having extended all sort of support when it comes to this program, which is being organized today as 4th edition. You must have seen just now a small video when it comes to our journey which we started 2 years back, and it has been a magnificent journey. And I am very happy to let it be known to all the gathering here that right from the first edition, which we had in the year 2022, Justice Ghosh had also extended his, you can say, speech out here. He had been a part of this journey, and he had basically come here. He basically helped us understand as to what constitutional law is. Then Dr. Kamaraju had also come all the way, right from KSLU Law University. Then we had also the presence of Dr. Rao from Nalsar. Swatantra Kumar had also been here. In the previous editions, he had also enlightened the audience. In addition to that, there was also one Revered Swamiji, because in the 3rd edition, we basically celebrated here Keshwananda Bharati's 50th years anniversary, and for that matter, Swamiji from Adnir Math had also come and shared his invaluable experiences that time. So today we had the 4th edition which we are doing here, and once again let us give a big round of applause to all the dignitaries who are sitting on the dais, please, who have extended our invitation to be here. So this is how this journey started, and may I also let you know that this is not only the program where our MLS students are participating, we also have the esteemed presence of dignified dignitaries, directors, deans, HOIs, HODs from KSLU affiliated law colleges who are also here. So they are also coming here to bless us today. So we are just trying to create that kind of understanding in the minds of people as to what Constitution is and what Constitution could be in times to come when it comes to global issues which we are facing as a global society. Because Rigveda has also said, Vasudhaiva Kutumbakam, so the whole world is one society. So let us try to come together, let us try to understand all those ifs and buts or nuances or
Thank you, Dr. Rahul. Moving forward, I would like to invite Professor Dr. Ali Farhan Gulrez on the podium for the brief introduction of the guests.
Good morning, everyone. A very warm welcome to you. I'm very thankful to Justice Prasanna B. Varale ji, sir. Kaushal Jain Thakur ji, sir, you are here. It's our pleasure. Justice Indresh, sir, it's our pleasure to welcome all of you, sir, dignitaries here on the dais today. This is the first time, students, we are very, very lucky that a sitting Supreme Court judge is amongst us here. May we give a good round of applause to Justice Prasanna B. Varale. So, as I was reading about, this is the first time I'm meeting Justice Prasanna Varale. As I was reading, his life has been full of struggles, and I think we all should learn and we should get inspired by his life, that if he can reach to such a big stage, we all do have a potential and capability. We can get inspired by such luminaries and we can get inspired by him. So I would just like to give a brief introduction of Justice Varale. So sir was born on 23rd June 1962 at Nipani. Okay, just, okay. So, okay. So then we'll just come to Justice Indresh. So Justice Indresh was, he obtained his education as Pandavpura town. Okay, so we are very thankful to all our guests who are here, and we just students, please listen to all of these guests, and then we think we will be heading towards a great function. Thank you so much.
I request our director, Professor Avinash Tadich, to present a memento to the Honorable Judge of Supreme Court of India, Mr. Justice Prasanna B. Virale. I request Dr. Rahul Mishra to come up on the dais along with Professor Avinash Tadich to present a sapling to the Honorable Mr. Justice Prasanna B. Virale. I request Ms. Purvi, Assistant Professor, Manipal Law School, to present a sapling to Mrs. Geeta B. Virale. I request Professor Avinash Tadich, Dr. Rahul Mishra, and Dr. C.G. Manjunath, Associate Professor, Manipal Law School, to present a memento and sapling to Honorable Judge of High Court, Mr. Justice E.S. Indresh. I request Professor Avinash Tadich and Dr. Ali Farhan Gulrez to present a memento to Honorable Justice Dr. K.J. Thakkar, the Chairman of Gujarat Human Rights Commission. I request Professor Pavan sir to come up on the dais to present a sapling to Honorable Justice Dr. K.J. Thakkar. This is also a joyous occasion as we have assembled here for the comic book release on the Constitution of India, which was jointly prepared by Manipal Law School and Shrishti Institute of Art, Design and Technology, MAHE. May I request the dignitaries, Justice Prasanna B. Virale, Justice E.S. Indresh, Justice K.J. Thakkar, Professor Arindam Das, Director SMI MAHE, and Professor Avinash Tadich, Director of MLS, to please release the book. Can we have a huge round of applause? Can we please have a huge round of applause? I request our Honorable Director, Professor Avinash Tadich, to come up on the podium and grace us with his words of wisdom.
Om. Honorable Justice Morales, sir, Justice Indresh, Justice Thakre, my dear students, faculties, colleagues, and dignitaries from other law schools, various high courts, people are in online mode. It's a great privilege for any law school to launch the 4th edition of a constitutional law lecture series. When we started this concept 2 years back, when Rahul came to me with an idea, sir, we should have something in the constitution law. Frankly speaking, I don't know much about constitution law because my specialization is competition, IPR, technology, AI, data privacy. I said, yeah, the idea looks good. Let's do it. So we started this concept, and the first idea we developed that this law school should not be seen as an elite law school. Though this building, infra might look elite, but this law school should be open for all. So sir, from the first edition, in our all programs, we always invite students and faculties from all over Karnataka, from Dharwad, from Mysore, from Mandya, different law schools in Bengaluru. We provide transport facility, we take care of them. The idea is that all law schools should feel that we are the part of the legal education system. So this is our 4th edition, and I'm so happy that a lot of from different law schools. So thank you very much, sir, for your help and your guidance. Coming back to today's edition. So then Rahul and we discussed what should be the theme of this 4th edition. So then one idea came up, the social justice. Social justice. It looks very simple word, but when you go deep, then you realize that it's very different. Social justice. There is a lot of contradiction. Because in a society, there are different stakeholders, different vested groups, and they all want justice. So a rich person, he wants justice, that his property, his intellectual property, tangible as well as intangible, should be protected in a democratic state. At the same time, some other groups, they want that the property rights should be properly distributed, and there should be equal opportunity for everyone, and there will be equal distribution of the wealth in the society. So when we say society, there are various groups, tangible, intangible, but then the job of a law is to make a justice. And justice is again not a static concept. It keeps changing. What was justice before 100 years might not be justice today. So in a dynamic society, especially in a country like in India, because most of the, because I'm coming from AI law background, so most of the companies, they are interested in Indian data. Reason being because this is the most diverse data. You cannot find that diversity anywhere. Even if you go to Europe, there they speak 28 languages. But still you will find there is a common culture. There's a common value system. In India, I believe that when you move from Kashmir to Kanyakumari, from Gujarat to Northeast, you will find different parts of India, different value systems. So it's very interesting for a legal system to understand the diversity and understand the constitutional values. Because whatever justice we do, we define that justice must be within the boundaries of the Constitution. I think that's the game. In the game theory in economics, I hope that you have read the game theory in economics. That's a very interesting. And in the US, they developed a very interesting school that is called Law and Economics School. So law and economics analysis does the economic analysis of the laws and the legal institutions. So entire the US legal system is based on law and economic analysis. What they believe that a legal institution or a law cannot survive until unless it has some rationality, until unless it's creating efficiency in the society. If a law or bringing any legal institutions like a regulatory body or any tribunal, we need to do a proper economic analysis. That's not very common in India. I think that's, unfortunately, most of the law schools even don't teach law and economics approach in the law schools. That's very bad. But in US, in the Chicago Law School, in Harvard, it's very common that there has to be rationality. But that rationality must be within the boundaries of the Constitution. Because as an economist, there is no boundary. An economist can give you, like there's a very small funny joke, like if the 7 economists are in this one room, they can come up with 8 ideas. So that's the flexibility lies with the economist. However, for a legal jurist, that flexibility is not there. Whatever we see, whatever we think, do right, from a small judge to the Supreme Court judge, there is a boundary. And that boundary is constitutionalism. But that boundary is flexible. There is a boundary, but that boundary is flexible, just like you can say metaphysics, that there is a boundary, but it's a flexible. It keeps changing from matter to, different thing. So in this constitutional lecture series, we always like to talk about constitutionalism more than the Constitution. We are very big fan of Constitution. But what I believe personally, and I told Rahul also, Rahul, we should talk more about constitutionalism because we don't want to talk about the case laws of the Constitution or the various articles of the Constitution. They are important. But in such a big gathering where one Supreme Court judge, High Court judges are there, we should not talk about the substantive part of the Constitution. We should talk the philosophy of the Constitution. Because in a law school, in an academic environment, we need to talk in a free environment, in a liberal way. Because when you talk about articles, somehow you are bound by jurisprudence, you are bound by our precedents. Because we are following the common law system, unlike civil law system, where precedents are not validate enough. So we started this constitutionalism idea. And interestingly, last 3 editions went very well. We invited some top-class judges, top-class academicians, lawyers, and last time we talked about the Keshwanand Bharti case. I think Sir was there last time. So we talked about what is the relevance of Keshwanand Bharti case today. Let's talk about it. We celebrated that Keshwanand Bharti case. So idea is very simple when I talk about social justice. I think this is very relevant now. Why this is relevant? Country is growing, and I think it's a great movement. I think in last 300 years, I can say this is the golden moment in India. If you go back, maybe 1723, you should not forget, till 1825, India used to have the second position in the GDP. We were the second largest economy, 24% GDP, China 25% GDP. But after 1825, things started moving, and now we are having only 4% of the global GDP, but we are growing very fast. So this is the best time. This is the golden time in India, where things are moving in absolutely right direction. Economic growth is happening, infrastructure is happening, people are excited. If you see the happiness index of Indians, how optimistic they are about future, then interestingly you will find that globally we are doing very well. Because if you talk about the Europe or US or Africa, there's always some apprehensions about wars, conflicts. This is the only place where we are having very peaceful time. So this is the golden time. But during the golden time, we should not forget that there are challenges. I think our ancestors did that mistake in 1825. When we had the second largest economy, they never understood that the world is changing. The world is changing. Now the new world order is emerging in Europe. They used to think that we are the powerful, we are the second best, nothing is going to change. But then change suddenly changed. Within 50, 60 years, entire thing went in the right to left. So when we are in the golden era, we need to understand things are changing. At that time, technology changed, the entire navy system changed, the world banking system changed, the new formation of companies came, the finance from the public to the East India Company like. So the power moved from state to companies. The UK Queen never invaded India. It was East India Company. It was a company's initiative, and it was an initiative by a company which was funded by common Britishers. It was a shareholding company. The common Britishers, they invested in that company and say, okay, we are investing in your company, go to India and make some money. Same thing happened with the Dutch. It started in Netherlands actually. I think interestingly you will know that the concept of company was started in Netherlands. What is changing now? That's my concern. Geopolitics is changing. China, the behavior of China is changing. China is going down, we all know. It's a 4% economic growth only. There was a gentleman understanding in China between the state and the people that if you give us 8% economic growth, we won't ask for democracy and civil rights. And they never ask for it. But now that gentleman agreement is going away. Economic growth is only 4%. Unemployment rate is 25% in China. Europe is not very keen to do business with China, same thing with US. Things are changing at the global order. Then there is a war in Russia, there's issues in Middle East. Things are changing. So what we need to do now, when we talk about social justice, then we need to empower our common people. Because still you should not forget that 85% of Indian population is making only 15,000 rupees per month. I repeat, 85% of Indian population is making only less than 15,000 rupees per month. Indian economy is big, but it's not just. 15,000 is nothing, you know that. In this country, if you want to survive with 15,000, it's a tough time. 80 crore people are still taking food from government. So this is our challenge. We will grow, no doubt, but if we don't address this issue, this justification of this discrimination, it might create a lot of challenges in next 10 to 15 years. Because then there will be clear, like the French Revolution type of scene, have and have not. You should not forget that French Revolution did not take place because of some philosophical ideas. French Revolution took place because people didn't have bread to eat. It was simple case of not having enough bread. In Paris, there was no supply of bread that year, and finally they decided, let's go and kill the queen. So it's a very important to understand from the law side. I think a very interesting debate is happening in Supreme Court. I don't want to comment on that, but that's a very interesting debate. That the Article 29, equal distribution of the wealth. You should not forget that the GDP to tax ratio in India is still very less. It's only 19%, sir. So our GDP to tax ratio is only 19%. In US, it's a 30%. And in European countries, it's above 40 to 45%. It means that still less money is coming through taxes. That's a problem. Because people who are making 15,000 rupees per month, they are not paying any taxes and they should not pay. What about the other people? Are they paying enough taxes? And you should not forget the Chanakya Niti when he said very clear that a state cannot survive and grow until unless they have a very robust and just tax system. The people who have more money, they should pay more taxes. The people who have less money, they should be supported by the state. That was the Chanakya Niti. So in India, when we say only 19% GDP to tax ratio, this is alarming. It's an alarming situation, sir. If you want to grow for a Viksit Bharat, and we should be, and we will be, no doubt, but then this GDP tax ratio should be minimum 35 to 40%. It should be double. And who is going to pay for it? Not 15,000 rupees guy, the people who are making more money. Then definitely they will cry that why, but this is the question which lawyers, judges and legal community and philosophers need to address. Social justice. How to help those people to grow. I think we have done very well in last 75 years, but long way to go. So I hope this in this constitutional lecture series, we will have good discussion. And with this spirit, we introduce this comic book also. I think this is India's first comic book. Thanks, my students are there, Srishti's students. So we collaborated with Srishti School of Design and we developed one comic book on the constitution, law and legal rights. And our students are doing a lot of social projects. So my request to all faculties and students that we have a social responsibility. Okay, we are not like engineers or doctors or CAs. As a lawyer, we have a huge social responsibility. We are a social engineer. So please learn, read, understand, and help the society, the needy people. So my students, they are doing social project, and as a dean and director of this law school, Manipal, I believe that we need to create a system where everybody should get the right path. Finally, I would like to quote the Voltaire, the French philosopher, very famous one. What he said, that I'm not worried about money, I'm not against the wealthy people. My only concern is that a person should not be so rich that he can buy someone. Or a person should not be so poor that he is ready to sell himself. That he said in 18th century, the founding years of the French Revolution. So we need to understand that where we are heading to. Thank you very much.
Thank you, sir, for enlightening us with your thoughts. I would now like to invite Honorable Shri Justice E.S. Indresh, a very reputed and respected judge of High Court of Karnataka, to enrich this gathering without any further ado.
ಎಲ್ಲರಿಗೂ ನನ್ನ ನಮಸ್ಕಾರ. Honorable Justice Varale Saab, Justice Thakkar-ji, Dr. Avinash, learned professors, students, invitees, and Additional Advocate General Mr. Santosh, and invitees. So I never thought that I have to speak first, because my Lord is there, so that just I have to hear him, that's all, except that nothing much is required. But when you see, insofar as the subject is concerned, constitutional law and social justice. In fact, there are 5 words out there. One is constitution, another one is law, third one is and, next one is social, last one is justice. Without constitution, there won't be law. Without law, there won't be society. In the society, we require to have a justice. See, if you look at all these things, dear friends, in the way back, the Honorable Supreme Court in F.L. Balsara said so. With this, when The Indra Beriberi has come, judgment. The Honorable Supreme Court says the preamble to the Indian Constitution is not a part of the part of the Constitution. It has to be read independently. How far, of course, in Keshavananda it was rectified. If you look at the judgments rendered by Honorable Justice Sikri in Keshavananda Bharati judgment, where the Supreme Court say that you cannot read the entire Constitution independent of the preamble, because preamble is the signature tune of the Constitution. It is a footnote to the Constitution. Preamble is a footnote to the Constitution. When such being the case, if you read the preambular objects with the constitutional provisions, vis-a-vis the judgment rendered by Honorable Justice Chinnapreddy in D.S. Nakara's case. Please read, I appeal to all the students, please read the judgment rendered by the Honorable Supreme Court in D.S. Nakara in 83 Supreme Court. Then we come, why social justice? Because justice at political, economic, and insofar as the social rights have been embedded in the Indian Constitution. If you look at insofar as the social justice is concerned, it is not today that we are insofar as saying about the social justice. It runs through the entire provisions in the Indian Constitution. It's a golden thread in the Indian provisions under the Constitution. Apart from that, insofar as the value-based society like us, the social justice plays a vital role. The question is whether it was conceived only by the constitutional framers at the time of framing our Constitution after 1948, where it was placed before the Assembly on 26 November. It cannot be. It was there in the society itself, because when there, if you read the judgment rendered by the Supreme Court in Mandal Commission case, social justice, what was viewed by the Honorable Justice B.P. Jeevan Reddy in that judgment, it is a doctrine of melting point. It's a doctrine of melting point. So in a melting point, where you can see everything, you provide all the resources should be utilized by everyone. If while doing so, you must give importance to even insofar as protective discrimination is concerned. That is called as doctrine of melting point. If you give a importance to the protective discrimination, while reading 15 class 4, 16 class 4 with the Article 14, because we are in an egalitarian society. In an egalitarian society, the resource should be distributed amongst the people equally. When such being the case, the Honorable Supreme Court in that case said that is when it's a protected discrimination, it should be there. Because if you give a very small example on this aspect, if a mother is having a child of 16-year-old and as well as 2 years old, 2 children, and she is having only one chocolate, normally she will give a chocolate to the 2 years old, not to the 16-year-old. Both of them, their own children. Can you say that the mother is discriminating the children? We cannot infer, because that protective discrimination is already embedded in the constitutional provisions 14, 15, 16. These are all the provisions, those are contained in the fundamental rights itself. But insofar as if you look at from the angle of directive principles of state policy, where we have borrowed it from Irish Constitution. If you look at the B. Shivarau's the book on constitutional the debates, when the constitutional framers wants to incorporate the directive principles in Part 4 of the Indian Constitution, insofar as they dealt about the two important articles, that is 38, Article 38 and 39. If you those articles, 38 gives 38 and 39 articles, it say that it is nothing but a direction to the state to make policy, to take policy decisions insofar as ensuring the social justice in the society. Even if you take for an example, insofar as, because recently we have ongoing elections process is going in our country. Normally, insofar as a legal student, as a law student, we have to look into the manifestos of each party, then we have to vote. That's what I infer, actually. If you look at the manifesto of each party, it should be contain what are the elements of social justice in their manifestos. Based on that, we have to cast our vote, actually. Likewise, in the event if such a government is coming to force, then they must ensure that whatever are their manifestos, saying about the promoting social justice in the society, that is the outcome of the policy to be taken by such government in the state. Because we are in a democracy, demo plus gratia, ruled by many. When such being the case, in a democratic country like us, insofar as the importance of the social justice, where you say that everyone deserves equal economic, political, social rights and opportunities. Not only the rights, opportunities. That means, as the director would rightly pointed out, that the wealth distribution of opportunities and the privileges in the society will be the goal. When access to all, the Constitution itself will say that access to all, why not the social justice access to all? If you look at the certain provisions under the Constitution, particularly insofar as the Article 21A, which was incorporated subsequently through 86th Amendment, where right to education up to 14 years was made free. That's a concept of social justice. Can you say that the right to education was not there earlier? Or where there is no, insofar as the provisions, such a provision was not there in the policy decision taken by the government since inception of 1950, or up to Moini Jain case or the Unikrishan's case? That is not the case. It is there in the Constitution itself at the time of framing the Constitution itself. That's why, as long this Constitution survives, because we survived nearly 75 years, is celebrated the independence, where if you look at the preamble to the Indian Constitution, first I would say, dear friends, if you look at the opening words of "We the people of India," because people are at the back of the Constitution. It is not whether the Constitution is important or the people are important. It's a matter of discuss. It's discuss to be point. Because we the people of India means, take for an example, there must be some, so when Constitution came into force, I am not born. Whether I am a party to the framing of this Constitution, whether I am bound by that, this was a question insofar as a law student from Cochin University, in fact, normally I used to take. So as soon as the draft from Kochi University asked Ambedkar ji, sir, you have made a lot of discussions for nearly 2 years to draft a very great constitution for a great democratic country. How far it will survive? How far it will survive? Because reason is, by that time we have 6 French constitution. Amendments have been made to the Bill of Rights in US. Insofar as US is concerned, House of Lords is laying down the many judgments through upholding the fundamental rights, though it is an unwritten constitution. Then Ambedkar ji say that, as long as the people abide this constitution, as long as we allegiance to this constitution, that means as long as we give importance to the social justice, till then the constitution survives. See what a great words rendered by the Ambedkar ji on that point. Because it should come in our mind that not merely we have to read through the constitutional provisions or from the judgments of the Honorable Supreme Court, it should come in our mind itself. Social justice is not a beginning, has not begun from the inception of the Constitution. It is runs through the generation. It runs through the generation. Because as I pointed out to you, insofar as though the Honorable Supreme Court in S.R. Bommai case say that social justice is the basic structure of the Indian Constitution. It may not require also, of course, because it is there in the entire gamut of the provisions under the Indian Constitution itself. But of course, while doing so social justice, give importance to rights of liberty. When you have a right of liberty, as enunciated by the Honorable Supreme Court in Maneka Gandhi, rights of liberty in Maneka Gandhi must go along with the social justice what rendered and conceived by the Honorable Supreme Court in D.S. Nakara case. If you balance this, both Nakara's case as well as the Maneka Gandhi's case about the rights of liberty, that's what we have to understand, the social justice in India, and that is our dream as such. Insofar as the 5 aspects relating to the social justice, what I used to say, one is substantive equality. Substantive equality means there must be no discrimination, subject to provisions of the Constitution, subject to provisions. That's one. Secondly, there must be a creative expression. Creative expression, that what we have seen recently by the judgment rendered by the Honorable Supreme Court. So insofar as the 19-1A speech expression is concerned. And thirdly, insofar as practice one's own religion, what we have seen in Article 25 and Article 26. See how the Constitution framers have given us a very great Constitution for us. How they have, insofar as they put these provisions into the Part 3 itself. So, practice one's own religion, 25, where Article 25 and 26 provides for the aspects or elements of social justice. Then nextly, right to privacy, that what we have seen in the judgment rendered by the Honorable Supreme Court Puttaswamy case, where the earlier MSM Krishna's case was watered down. There's a fourth aspect insofar as the social justice is concerned, right to privacy, we need to have, subject to certain restrictions. And lastly, right to enforce our fundamental rights. See, merely giving provisions under Article 32 and 226 under the Constitution, or where the constitutional provisions have been made, Part 3, from Article 12 to 35, without enforcing agency, without insofar as the constitutional courts have to look into the, as a guardian of our rights, fundamental rights is concerned, then there is no value for these constitutionalism. Therefore, as long as these enforcing agents, that is judiciary, now the judicial review is there. Judicial review is nothing but interpreting the Constitution, what was dreamt by our constitutional framers, vis-a-vis that of the changing society. Maybe technology now has been incorporated into the many aspects, but however the value system is as conceived by our our constitutional framers. In this regard, I appeal to the students, please read the Bharatiya Vidyabhan's book. I think they have published on the Alladi Krishna Swami here. So one of the wonderful book where we can see how a discussion was made during the Constituent Assembly regarding each of the subject. Take for an example, secularism or social justice. These are all the aspects of democracy. Though they were not find a place at the time of conception of our Constitution, they have been incorporated during 1976. Don't think that it was not there in 1950 Constitution. It was there, but it was not expressly find a place in the preambular objects concerned. Therefore, anyway, we need to hear his lordships on the social justice. I think I shall be very grateful to sir because the Manipal University has invited a right person to speak on these aspects. I think, except sir, I think Varale Sahab, so he's just like a fatherly figure for me. So he is the one who is example for what Indian Constitution conceived for social justice. So thank you one and all. So please, dear friends, see, have in your mind, this country has given us everything for us. Do good things to the country. Ultimately, the country is first, we are all second. Thank you one and all. Namaste.
Thank you, sir, for your presence in this program. Your words have been highly inspirational. Next, I would like to invite Honorable Justice Dr. K.J. Thakur, a former judge of Allahabad High Court and the chairman of Gujarat Human Rights Commission, to guide us with his valuable words and experience.
Good morning, everybody. Namaste. My Lord Justice Varale, Madam Varale, my esteemed colleague from the Karnataka High Court, Dr. Dadich, Rahul addressed Mallikarjun before him because it is because of Dr. Mallikarjun that I am before you. It was at the Christ College where Rahul met me and said, sir, we have this series and I would like to call you. I said, anytime, because I am myself a student, a registered student for LLD. And all my students here who are my colleagues, maybe younger colleagues, and all my revered teachers who are sitting here. This is a very important topic which has been posed by both Rahul and Professor Dadich. We are in times when we are at some crossroads. What are these crossroads? Most of them have been covered by my brother Idvish. I'll have to either shorten my speech or I'll have to bring out some new ideas which I might have had, because most of the topics which I had decided to speak on have been covered. Say, what is the basic requirement of justice? This is a simple question which I am asking all my students here. The simple requirement of justice gives an occasion for development of new dimension of justice. And what are these new dimensions of justice? And as a law student, I was given a book on famous judges, lawyers, and cases of the Bombay High Court, published in 1962. And in all my lectures on human rights, I narrate this incident from page 222, 228, which I think as a student I had mugged it up. And it is still in my minds. And I normally quote it, and which you may permit me to read, with your Lordship's permission. An important aspect of social justice, being absent pre-independence era to some extent, can be demonstrated by referring to the British era, by quoting reality of the misnomers of the court. A question may arise to my young students: how can they be misnomers of courts? Can court cause misnomers? The answer would come immediately when I read these two case laws, rather the facts. Indians were so suppressed that even magistrate would not hear the servants of the European man and woman. It seems that I take a pause because the moment I start reading it, tears flow from my eyes. That were we in this situation? And thereafter the Constituent Assembly started debating on why India should be a socialist country, why we should have social justice, why should there be political justice, why should there be equality. It seems that in old times in Bombay, it was common for the European man and woman to send their servants to a magistrate with a note complaining of the servant's misconduct. Only a note, nothing beyond that. In most cases, the magistrate proceeded straightway to act upon the note, convict the man summarily without any sort of trial, and punish him on the spot, generally with flogging. And occasionally even with imprisonment. This thoroughly lawless practice seems to have continued till almost the time of establishment of the High Court. So till the Bombay High Court was established in Bombay, we had this lawlessness. a European man writes to the magistrate that this man has remained absent. He has ran away and come back after 4 days. That's all that he needed to do it. Now this is the Darji's case which brought about what I call total transformation in that system. A Darji employed by a European was punished in this summary fashion with 3 months imprisonment for leaving his master's service without leave. But the Darji refused to take this outrage meekly. He filed a suit against the magistrate named Cornfield for damages for wrongful imprisonment. The suit was heard in the High Court, and Westrop, who was then at the bar, was engaged for the plaintiff. Westrop fought for his client stubbornly, and substantial damages were awarded to the Darji, for he had a just excuse, which the magistrate never cared. See, why I am pointing out this aspect to you. See, we have come a long, long way. In your first year of law, also you are taught what are natural justice. What are your fundamental rights? What are your rights, basic rights? And these rights are not given because of the statute. They are because of your birth on earth. They are known as your basic rights. And what are they? What is the basic right? Equality. And as I tell, no human being is born equal. Maybe this may sound slightly off track in these days. Just imagine, are two brothers born with equal mental equilibrium? Are two sisters with the same kind of thought process which would go on? Now, how do you bring about an equality in them? That is where social justice comes. And that is where your role as law students is more focused in these trying times. See, as we were taken through all the photographs, you are the pillars now who are to go to the society. We found that even after 75 years of independence, there were some areas in the rural background of Karnataka where some of the students told us that when we went, the people didn't know what their rights were. Forget fundamental rights. So you have to inculcate in them. Maybe you are, as my brother Justice Varale told to some of the students there, that you don't have to sit in this ivory tower of this college. Go there. And that is why we have now, all these universities have legal aid camps where you have to take part. In our times, they were not there because we didn't feel the need. Now they are there in your curriculum. Say, as early as 1985, then Justice Chandrachud, in that famous case of Olga Tellis, which most of you would read when you take your second or the third year of law course, because during your first year and the second year, you will not have the constitutional ethos to be taught to you. So that Olga Tellis, what is Olga Tellis's judgment? That is again in the social rubric of the country. Just telling or having such conferences is not going to elevate their status. It has to be the rhetoric, it has to be kept in practice. And if we go by the recent judgments, did we ever think of that having internet would be considered to be a fundamental right? At least I had never envisioned till 2010. Because I had not heard about internet those days. So there is a transformation. As I was discussing, when I became a young judge, see, we all have aspirations. Why? Because we are enamored by the movies which we see, by the stories told to us by our parents, by our elders. I was also enamored that, yes, as a judge, मेरा ये power होगा, मैं इसको ये न्याय दूंगा. But the day I stepped into the court, I was made to sit in a lobby without a fen, without a matka, and all my dreams shattered. You people today in these law colleges are much better equipped. So you should thank your parents before thanking anybody else. And why parents? Because they thought it proper to send you to such a good university where you can educate yourself. Now, as brother told, what is educating? It's not only learning from the books. You have to inculcate things in yourself. The values. And what are these values? Everybody lives for earning. I too, you too. One more aspect which I should not dwell, and I would not even delve into it, only a passing remark on the constitutional ethos and the motive with which we are talking about socialism. And not delving on the issue of whether article on property rights has been properly shifted or not shifted from the fundamental right regime to the other right regime. Because that would be debated by the ultra-sepidarians who are going on in the country discussing on this. And I would love to quote none other than the great Justice M.C. Chagla, who in my state, in 1975, during those dark ages, though I consider it to be partly a dark age, and being a student of environmental jurisprudence, consider it that the other half was not that dark, not that murky, because of the 42nd Amendment, which brought in the chapter on an environment, to which we were wedded. And that is where the social changes started after 1975. Right to environment has been considered to be the fundamental right now. I would just quote Justice Chagla. While he was delivering lecture in Ahmedabad in 1974, in my homeland in the year 1975, stated as such. He had a question, what is the position today? Is anything like civil liberties in the country? Therefore, human right, or rather synonym word, civil liberty can't find place in the period of 1975. He further stated that ours is a system of ordered liberty and not licensed. So the basic idea of social justice, in short, is to bring a transformation. What is this transformation which we want? It has to be a transformation for the better of all. If you go by certain articles written in 1983 by Upendra Bakshi, you'll get a clear insight on this aspect. And as I have been always telling, right of workers, I correlate it with the incident of that Darji. See, right of workers under the Company Law or the Factories Act has now been considered to be a redressal approach by the 1995 judgment, where certain people suffered due to the working and use of asbestos. They would have fibrosis. A PIL was filed in the Supreme Court. हमको लगेगा कि ये, why this petition here? They can file a suit, they can file, because it was considered to be a fundamental right of health after the Olga Tellis judgment. And the Supreme Court said yes, they have to be compensated by the owner because he is earning out of their bad health. This was never thought of in pre-independence time. We could not have even dreamt of this. Later on, now, gender justice, Vishaka's judgment. My brother said about D.S. Nakara's judgment, Olga Tellis, and the recent, very recent two judgments, and the recent discourse, if you are subscribed to Live Law, Her Ladyship, Justice Nagaratna, in this very city, on 23rd of March, has given a very good discourse on what is social justice. I think my time is up. I would end my comment with the quoting of free primary education. Could we have thought of it in pre-independence times? It was because of the constitutional mandate added by the constitutional law's vision that that is possible by way of a legislation. I at the end thank all of you. Why do I thank all of you? The reason is a speaker may have mugged up his speech for 5,000 years, but if there is none to hear him, what will you do? Therefore, I thank all of you for being here. और जैसे हिंदी में कहते हैं ना, हमारी हौसला अफजाई करने के लिए. Thank you, students. We see that you come with new dimensions like this book. I really thank you for this innovative idea in these days when students don't read books. Even in my lectures, even right now, I would be seeing students going through their Google or their WhatsApp. As I have been telling in Hindi, one of my stand-up comedian tells, and I normally end with a small anecdote so that you smile and don't feel that much bored. Your yawning stops. WhatsApp is like a mother going and checking her too-old child's diaper. Kuch aaya, kuch aaya. Thank you.
Our hearts are filled with gratitude and we thank you for your kind words. Ladies and gentlemen, it is with great honor that Manipal Law School has the privilege of hosting Honorable Mr. Justice Prasanna B. Varale, who is serving as a Judge of Supreme Court of India, is a former Judge of Bombay High Court, and has also served as Chief Justice of Karnataka High Court. With all due respect, I request you to come up on the podium and share with us a part of your journey as a lawyer.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. My esteemed brother, Shri Justice Indresh ji, Honorable Justice K.J. Thakur ji, Lieutenant General M.D. Venkatesh ji, Vice Chancellor, Patron-in-Chief Shri Veera Raghavan ji, my dear Shri Avinash ji and Rahul ji, the members of the organizing committee, Shri Mallikarjunaya ji, my better full Geeta. I always say that it's wrong to call her better half because her entry made my life complete. So my better full Geeta in touch with me with his warm and affectionate calls, messages. And well, I must also thank my brother Indresh ji, who told me that, sir, Manipal Law College would arrange a function and please see that you attend the function. And Rahul ji, when we were just opening the function with lighting of the lamp, and you were there on the mic addressing the gathering with Saraswati Vandana, it also reminded me, Rahul ji, you are from Dharamshala, and His Holiness Dalai Lama said, what is light? What is kindness? And His Holiness said, light is nothing but absence of dark. What is kindness? Remove the greed. So removal of the greed, absence of the darkness, that is the light, that is the kindness. And probably this was with that noble concept of His Holiness, we started our function. It really gives me an immense pleasure to be called here today for this 4th edition of Constitutional Law Lecture Series. I must again mention Dr. Ali, who was there in the opening part. It is really a great event to celebrate and congratulate Dr. Ali being a very, very fortunate son of a great mother. Recently, his mother is nominated as the Vice Chancellor of Aligarh Muslim University, probably the first lady Vice Chancellor. Let us give a big hand to Ali ji and his mother, a great woman. Well, I must also congratulate the students. I was very happy myself, my wife Geeta, when we visited the projects undertaken by these students. They were so focused on their projects. They took the pains. It was the hard work of these students, 4 months, 3 months, and they were discussing these issues, sharing with us, with all their enthusiasm, their zeal. The inauguration of, or the release of the book, which is in the comic form, an introduction of the Constitution for a common man. And really it's a very novel and very, very useful project undertaken by the college. Normally, it happens, anybody, when you take a book and the subject is a little serious like Constitution, you lose your interest. But then to see, immediately pick up a copy of the comic and try to read it, finish it. So this is the way how the subject is made interesting, and I congratulate the entire team for undertaking this project, and I'm told that recently, in near future, the project is to translate the book in all languages, most regional languages. So I congratulate the teaching members and my young dear students. I always say that you are such full of energy. You are the energy houses. Only the need is to channelize the energy. The energy, the enthusiasm is of such level. Let me just share a wonderful couplet. You must have heard name of a great poet, Dushyant Kumar. And he says, कौन कहता है आसमां में कौन कहता है कि आसमां में सुराग नहीं होता? कौन कहता है कि आसमां में सुराग नहीं होता? एक पत्थर तो तबीयत से उछालो यारो. So this is what the energy my young dear students have. Need is to channelize, and I am very happy that the energy is channelized in this wonderful way by undertaking these projects. Well, I am also filled with nostalgia when I am standing before you, primarily for two reasons. Firstly, it's homecoming for me, coming to Bangalore, giving me this opportunity is the first reason. And second reason, addressing gathering of dear students, reminds me my days when I was a short-time teacher, a contributory teacher in a law college in Aurangabad for 2 years. So looking at all these young faces, young boys and girls attending this function, it reminded me my days. Thank you, Rahulji. Thank you, Avinashji. Now today, I'm standing here with the subject and more focused on the 75th year of the Constitution, remembering and paying our rich tribute to the great man, Dr. Babasaheb Ambedkar, the framer of the Constitution. And believe me, a person from Dalit community like me was elevated, sitting in a prestigious High Court, Bombay High Court, then fortunate enough to discharge my duty as the Chief Justice of this great state, and now serving the greatest forum, judicial forum of this country. This is all possible only because of Dr. Babasaheb Ambedkar. I am standing here today only because of Dr. Babasaheb Ambedkar and the Constitution. The contribution of Dr. Babasaheb, first, foremost, in my opinion, is those who were hundred of years having chained with the unequal treatment, those who were just moving in a darkness of ignorance and illiteracy. For their fortune, a man born Bhimrao Ramji Ambedkar with the mantra of equality, social status in the Constitution, and focusing on the knowledge, he made them free human beings. He led them to light. And therefore, I always refer Dr. Babasaheb Ambedkar as Pradnya Surya. I know that probably you may not be very conversant with Marathi language, but I'm sure that this small couplet, which I feel describes Babasaheb Ambedkar, what Babasaheb Ambedkar means for thousands, millions of people like me. The poet is a great poet, recipient of Jnanapith Award, Kusumagraj, and he says, Tejo nidhi loha gola bhaskara hai gaganaraj. Tejo nidhi loha gola bhaskara hai gaganaraj. Divya tujha tejane zagamagale gaganaz. He is the sun. He was the sun shining yesterday. He is the sun shining today. And he will be shining tomorrow also. So this is a sun who is leading us, taking us to the light. So this is what I feel. And when I'm sharing with you some of the views on the topic, let me also tell you, I'm not posing an expert or somebody who is ultimate having a knowledge of everything. It's something, my feeling is some elder Shani Veliudin, Begum Ajia Razul, argued against the reservations and separate electorates for the scheduled castes and scheduled tribes. They believed that reservations would maintain an unbridgeable gap between minorities and majorities. Social and political equality for everyone was their foremost goal. Hansaji Raj Mehta presented the country's first national flag on behalf of the women of India and made several strong arguments against reservations. Industrial workers, tribal population. Our approach has also fundamentally shifted from formal dogmatic access to justice to a real and effective access to justice approach, thereby making our system equally accessible to all and leading to results that are individually and socially just. Though its directive principles, though are non-justiciable, but are still fundamental principles of governance, our Constitution mandates the state to strive towards establishment of just and equitable society where gap between privilege and welfare measures. The Constitution is based on, reference was also made by Dr. Avinashji, but he had his different opinion on it, called as the unity of trinity of liberty, equality and fraternity, conceptualized in the French Revolution. These principles should not be treated as separate items in Trinity. We know that, but then let me also share you, when we oftenly read this, that the term fraternity finds in origin from French Revolution, considered to be a significant revolution, but then Avinashji had a different point. This principle came into existence in the backdrop of monarchy and was seen as means to ensure socially from which I borrowed or was impressed by term fraternity. Baba Sahib refers that it was also another principle in Buddhism. When Buddha referred to the concepts prajna and karuna, these concepts were not synonym to the knowledge and the only sympathy. Baba Sahib referred to that prajna is something which you accept, not only somebody says, you accept it, firstly analyze it. If you feel that yes, this is what is stated is true to the conscious, yes, it is tested on a scientific assessment, then only accept it. And therefore Buddha said that even I say something and therefore you accept is, I will not allow you. You yourself test it. So this is probably what the scientific approach to which Baba Sahib Ambedkar was impressed of. Karuna, something which is also not a synonym, it goes beyond that. It's something where the principle of fraternity in Buddha's theory comes. It is looked as a compassion. It's not something only a charity. the term is with a more of a compassion, and the basic principle is a brotherhood, a fraternity. Therefore, Baba Sahib said that it's not only the French Revolution, it is the Buddha's theory, which I was more impressed of. And this is how it gave the idea of this fraternity concept. Well, in the landmark judgments of Keshwanand Bharti and state of Kerala, the reference is made. S.R. Bhumai, again the reference is made. I need not go to it. I can only again refer to the views of inclusion of Article 17, which prohibits untouchability. The advocates for social justice, ranging from Mahatma Gandhi, Raja Ram Mohan Rai, Swami Vivekananda, Dr. Ambedkar, had taken a persistent stand for tackling of social problem of untouchability. There were some voices about the term untouchability being little vague. Professor Shah contended that there is no definition for untouchability and hence phraseology of it being changed. Dr. Ambedkar was not in consensus with the above view, following which Article 11 of the draft constitution was passed, which came to be incorporated in our constitution. If we make reference for writings and speeches of Dr. Baba Sahib Ambedkar, in volume 5, it is written by him that untouchability has all the disadvantage of a free social order. In a free social order, the responsibility for survival in the struggle for existence lies on the individual. Responsibility is one of the greatest disadvantage for a free social order. Whether individual is able to carry out this responsibility depends upon a fair start, equal opportunity, and square deal. Hence, from this point of view, it can be said that untouchability is worse than slavery. When it comes to the reservations, we can also remember Hansa Mehta's words, where she had emphasized the hardship faced by women of these countries due to customs practices prevalent at that point of time. She did not advocate for reservation, but was concerned with justice, social, political, and ecumenical. Even Renuka Ray advocated against the reservation of women, but contended for the fair treatment. Let me also share with you the some of the contribution or achievements of Dr. Baba Sahib Ambedkar, which probably we missed, which are aimed at the social justice, more particularly an equal status to women. Dr. Baba Sahib once said that at those times, condition of women in this country is so bad that they are treated so badly, even somebody will not treat an animal. This was his concern. And just mind it, that when he was a labor minister, he introduced the concept of maternity leave. Many of us, we miss it. And this was done even, it was not there in the so-called advanced and developed countries. This was the concept, this was the principle of Dr. Baba Sahib Ambedkar's social justice. Also, we similarly miss the contribution of Dr. Baba Sahib when he was keenly professing for the upliftment and particularly economic upliftment. We also miss that Dr. Baba Sahib Ambedkar's contribution to the establishment of Reserve Bank of India, which is the basic financial body of this country, that when we talk about the other contributions, these are also the very important contributions of Dr. Baba Sahib towards the social justice. And it is also said that when he said that discrimination against women in traumatic transparency is found if a woman member shall obtain permission of the man before she marries. That reference was then again made, some reference was made by Thakurji. So, then reference was also made to Vishakha. Then again, Vinita Sharma's case, which has a retrospective application for co-parental rights of Hindu daughters. Shaira Banu, which struck down triple talaq. Article 21, which envisages life and liberty of a person, is given a very broad meaning, and its ambit has been ever increasing. It includes right to life, right to privacy, right to livelihood, right to live with dignity, right to shelter, right against harsh living conditions of prisoners, right to healthy environment. Some of the judgments we are aware, but then let me also remind it, like Nandini Satpathy judgment, Hussain Ara Khatun, where total of 40,000 prisoners were released as they were kept in jail due to unjustified bail system. The Supreme Court advised the Parliament to reconsider then the Constituent Assembly debates on Article 32, which during the debate, motion was forwarded to substitute the word guarantee with comfort. Hence, by guaranteeing a right to move Supreme Court for enforcement of fundamental rights conferred by the Constitution, Article 32 consists of right and remedy both, and is often regarded as very heart and soul of the Constitution. Well, when we are talking about the social justice, and while I was coming, published in the newspaper, let me not share the details. It reminded me an incident when I was in this state as the Chief Justice. Unfortunately, similar incident took place. I was surprised, and I was more than surprised, I was in pains to see that this is a repetition of such incident. I mean, how such thing can happen in this country, in the progressive state like Karnataka? I hope and wish some addressal or something to that effect can be done, but I just leave it to that stage only. And I again appeal that please don't make this issue anyway a politicized issue, anything, because now we are in a times of elections, etc. Please look it at purely an issue where we must focus and see whatever the remedial measures are needed. I am sure that brother is here, and I think in this regard something can be done. But I was really at pains. When that incident came to our knowledge, in court also I shared. I was disturbed, and it reminded me again a couplet of the great poet of this country, Sahir Ludhianvi, when he said, औरत ने जन्म दिया मर्दों को, मर्दों ने उनको बाजार दिया. In this country, in this era, if these things are happening, it's something, it really shocks your conscience. I think this is something where we can also come forward, do something. Dear friends, I like to take this opportunity to share something. You will become the graduates. You will all contribute in your own way toward the future of legal discourses undertaken in your nation. Some of you will go on become future judges and lawyers. Some of you might work at various esteemed law firms. Some might get into academics, professorship. My advice to all of you as you start in the legal profession, would be keep an open mind, willing to learn and adapt. Once you find your passion, hard work will not seem nearly as dreadful. From my experiences, the more hours you put in this profession from the start, more it will yield results for you in future. And well, not in some words of any foreign thinker, scholar, somebody, let me just conclude in the words of our own very simple Rancho. Rancho says, काबिलियत पैदा करो मेरे दोस्त, कामयाबी अपने आप पीछे आएगी. Thank you all.
Thank you, sir, for your generous words and valuable insights. As they say, all good things must come to an end. With a heavy heart, I request Dr. Ali Farhan Gulrez, Assistant Professor of Law, Manipal Law School, to come up on the podium for the vote of thanks.
Good morning, good afternoon indeed. Honorable Justice P.B. Varale sir, Justice Indresh sir, Justice K.J. Thakkar sir, and Avinash sir. First of all, I would like to tell you that it's a great auspicious occasion, day that we are witnessing such a great function. Believe me, people, you all are very lucky to witness this function because we are having all the people from around Karnataka, a Supreme Court judge, Human Rights Commission chairman, High Court judge, so please give a round of applause for everyone. Then I would like to tell you that how this journey started, and then we'll come on of today's program. So first of all, I would like to thank Rahul sir. It was his idea to come up with this program to Constitutional Law Lecture Series, and he came with this program. He came to Avinash sir, and Avinash sir is such a great human being and director. I always say two lines for Avinash sir, कि मैं अकेला ही चला था जानिबे मंजिल मगर लोग साथ आते गए कारवां बनता गया. Thank you so much, sir. Then I would like to say, if we come to our judges, so Justice P.B. Varale sir, sir, we know that how busy you are. You have taken time from your busy schedule. You have come all the way from Delhi. And for Justice Varale sir, I will just say two lines. जो लोग मेहनत पे भरोसा करते हैं वो किस्मत की बात कभी नहीं करते. About Justice Indresh sir, Justice Indresh sir has graced our occasion, Constitutional Law Lecture Series, third part also. He have very high regards for Manipal Law School and is a very good guardian of Manipal Law School. Thank you, sir, for coming again here. Thank you so much, sir. As far as Justice Kaushal Jayendra Thakkar sir is concerned, yesterday I met him first time on the airport, and in the hotel he took us, and it was not like that I am meeting such a big dignitary. First time he made us so comfortable. He's such a down-to-earth person, such a great human being. Thank you so much, sir, for coming here amongst us. The teachers who are here, Dr. Apurvi, Professor John sir, Manjunath sir, Pavan, Revti, Madam Varale. Yes. Madam Varale sir has rightly pointed out, she is not a better half but better full of Varale sir. And we have Madam Indresh also here, and Registrar General sir is also here. Tapan sir is also here. Thank you everyone, our teachers, Manjunath sir, Sunil sir, Apurvi ma'am, Revti, Pavan, thank you everyone. And in the last but not the least, I would really like to thank Mallikarjun Iyer sir is also there. So in the last, I would like to thank all my volunteers. I would name them because they had worked day and night from last many days. So Akriti, Akshita, Amruta, Ananya Patil, Ananya Reddy, Anushka, Ume Lamis, Cherian, Esther, Garima, Gayatri, Janvi, Kamakshi, Manasa, Milan, Milinda, Vidushi, Pakhi, Rahul, Rakshita, Sairam, Samyukta, Shret, Tanmay, Urvi, Vaishini, and Pavitra. Thank you all of you, my volunteers, every one of you for coming here, gracing the occasion. Special thanks to Vidushi for such a good comparing and anchoring. Thank you so much. Thanks. God bless us all. Thank you so much.
Within the words of our Constitution lies the blueprint of our nation's promise: equality, justice, and freedom for all. Let us honor its enduring legacy by upholding its principles with unwavering dedication, ensuring that every voice is heard, every right is respected, and every citizen is embraced. In the tapestry of our democracy, let us be the threads that weave unity, progress, and dignity for generations to come. As we stand united, let us honor our nation and values with the national anthem.
जन गण मन मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मागे गाहे सब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request all the volunteers and participants to come up on the stage for a group picture, further to which the students are requested to assemble for lunch in the MIT canteen, and our esteemed dignitaries and faculty are requested to proceed to the 6th floor in the MIT building. Also, all the participants, both online and offline, will be getting their e-certificates shortly. Thank you all for being a part of this occasion, and with this, we come to an end of our program.